Welcome, everyone. It's March the 14th of 2024, and I'm Tonson Fairmont. We're going to get started here with some great speakers. The very popular Will Barney, ex-banker and humanitarian, building the golden age with us. And Randall Hillner, our trust writer, will join us today. We're Brilliance in Commerce, a project of La Verite, which means the truth in French, and House of Freedom International Natural Law Trusts is our topic today. We're members of the Worldwide Charter for Fair International Commerce, as you may know. And for newcomers, go look at it at the website sometime, and you'll see some of the principles by which we operate. Today's the webinar World Situation Update and Development of the Quantum Financial System is part of the topics that Will usually speaks on. And in that context, he's going to give us a little news update. Let me find you here, Will. Okay, well, don't see you yet. You're here, Randall, so thank you. My name is Tonson Fairmont, so we'll get started. We'll just go ahead and wait a minute or two for Will to join us. And you're everyone in the audience. I mean, the people who have been with us for years, we welcome you and appreciate you and thank you. And the new people joining you are very fortunate. I don't know if you know how fortunate you are. We have some of the most essential freedom technologies: how to be free from debts, how to be free from taxes, how to build a financial legacy that is protected and that is outside the constraints of the old cabal's paradigm, the matrix, and do so safely, do so without the dangers and the retaliation that a lot of people fight with. We're into peace. We have established a very nice, peaceful situation with these technologies, and the Natural Law Trust is one of them. It's been crafted by Randall. He's been working at this for at least since the 1970s, and he had some of the greatest mentors who taught him. It's not taught in law schools. It's not taught to attorneys. It's something that the elite, the super rich, designed for themselves because they didn't want to be subject to the same rules and restrictions that they wanted to subject their slaves to. So they designed these non-statutory entities, and Randall has taken those designs and improved upon them. Some people collect coins, some people collect stamps. Randall collects clauses. And he's been creating one of the greatest combinations of clauses in an asset protection entity of any trust we've ever seen, or any asset protection entity we've ever seen anywhere in the world. These are the clauses that maximize the freedom of the trustee. It allows and even encourages the client who sets up the trust to be the managing trustee, and it maximizes the asset protection for the benefit of the beneficiaries. So we're going to have just a little bit of comment today from Randall, but we're going to proceed with Will as soon as he arrives, hopefully soon.
Hello, everyone. It's Randall on Kauai, checking in.
Well, go ahead.
Don't let those palm trees disturb you.
Yeah, go ahead and say a few words to us. I'll pause the share.
Oh yeah, well, it's welcome. We're in for a treat. I've listened to Will before. We've talked privately and together, and he's going to bring in, he brings in another avenue of knowledge that I'm not privy to so much. He's worked in one seat of the financial system, and I worked in the other. So he's going to add something, and I might pop in and add anything or help out with questions in the area of the trust law and how it protects your assets. So I'll just leave it, and I'll just back up Will whenever he needs my help or anybody has any questions.
We have so far 69 people, and we've been up as high as 120 with Will. So we should have more coming soon. And Randall, please say a few words more if you can comment while I try to reach Will. I'll see if I can reach him.
Sure. I think Will is trying to going to bring us up to speed uh, in how the banking situation is and what the new developments might be. And I'm just going to step in and because once we have those new elements of financial system, banking system, however it's going to play out, we're going to also need to have asset protection on a personal level. So it's not just about the government and about the finances and about the corporate structure. It's all about personal finances as well. So I just want to reiterate how the natural law trust adds to the ability for your estate to be totally protected. We protect your business. We can take your house. We can take your stocks and your bond portfolio. All of that can be combined or separated in a way that allows to have the best benefit. Okay, that help?
Your video's not on. If you would like to turn it on, I've sent an invitation to you.
Oh, you want me to show my face? Oh, I don't know. That's a pretty scary thought. Start my video.
There you go.
Hey, there he is.
Okay, we have a text message from Will saying running a few minutes late, so he'll join us soon. Meanwhile, let's have some uh, ohana, some family gathering.
Well, who else is here? I don't recognize the names. These are all, I think these are from a different club, and only a few of you have been involved with the Natural Law Trust. So there's not much to say other than you're in good hands with Brilliance in Commerce and what Will is going to bring you, what Tonson and I have brought you over the years, what other people have brought you. Dominique has been so brilliant in her addition, helping Brilliance, and now we have a new associate with Laura White. She's going to step in and help out as well. So we're going to be able to offer a number of things. We're a nominee grantorship, and we've changed our trust around so that you can be a trustee under certain conditions and operate your trust effectively. If you want to do that, you can be passive, you can be active, you can be anything in between. So I'm going to not do too much today because I want to listen to what Will is going to say, because I'm going to be speaking here next week, and I'll add to and be able to take the essence of what Will has brought new to the table and put it into a lecture for all of us next week, whoever wants to show up.
FJB, you wrote, Where are you, Randall? And he's in Kauai, the paradise garden island of Hawaii.
You mean those trees don't give me away?
Yeah.
It
And
is pretty much where I live.
tomorrow you've raised your hand, so let's hear from you.
Yes, I've been in the training for quite a bit, self-taught. I really appreciate everything that you guys are doing for us. And I wanted to ask, can I make the payment with an insurance policy?
I'm sorry.
Can I make the payment for the trust with an insurance policy?
I'm sorry, you have to say the whole question again. I missed the beginning of it.
She can pay for the trust with an insurance policy, and I don't know how that would be done. Forgive me if I'm missing.
Really?
All right, I will work out the details, but it's two of them and they have a face value, and this will be perfect start for a case study.
Okay. If you're able to translate that equity that you have in those insurance programs and it does pay for what we're going to give you, then I don't know, Townsend, do you think we could make something work?
Right. So that could work if you can somehow convert it to cash. That's all that's needed.
Right. Right.
Yes, I will take care of the details. Thank you for your permission.
Okay.
Thank you. Okay, I think Will's here. And Will, we're going to ask you to start your video and unmute and say hi to us. Meanwhile, Randall, someone's saying, what's happening with the people who had the directed energy weapons on the Lahaina people?
The weapon has disappeared, and now we're, pulling as much funding together as possible from all around the world to help rebuild that whole historic endeavor over there. And I don't get involved with the political esoteric elements of super beams coming down from someplace to ignite a fire in Maui, but I'll leave that to anybody else that wants to entertain that. And just say that what I want to do is help people protect their assets, whether it's a bolt of lightning or an emissary from a different planet, who knows? But if we have it in the right mechanism, if you have your assets protected effectively and all the signatures are in the right place and documents assigned in the appropriate manner, then it'll happen automatically.
Well, that's strange. Will lost connection. So he was about to come on and speak to us, and then he lost his connection. So I don't know what's happening.
Well,
Randall,
I have some notes from that I was going to do next week. I can just come in and we can ad lib it for a bit and I can entertain some questions. Would that work?
yeah, give us a little preview of what we're going to talk about next week. So
Okay,
everyone,
hold on one
March
second.
20th, Wednesday, March 20th, Randall's going to give us a new stream of education.
Drop calls is called Zoom.
Okay, I think what I'm gonna do.
So everyone, we have been using this natural law trust for a long time, myself since 1993, Randall since the 1970s, and his mentors before that, to the point where I don't even bank in my personal name. I mean, you could, and many do who use the trust. I just don't find any need for it because as trustee, you are authorized to pay your basic major expenses through the trust. And if you choose to, you can have a personal account and pay yourself a salary out of the trust as compensation for your trustee services. So it's been a first-class instrument. We've not had one single problem with any of the ABC agencies in the entire 5 decades or more that we've been using these. 100% success rate, never been penetrated, never been invalidated. All right, it looks like Will's joined us again, so let's try it one more time.
Can you hear me now?
There you are.
Hey,
Oh,
I
great.
can hear you.
You wouldn't believe all the stuff we had. I had to reboot my computer 3 times, all kinds of stuff to make this work. It's
I thought you were caught in traffic or something.
I a well, I probably would have made it on time, but none of the equipment wanted to work. It was crazy. It's like I had gremlins trying to stop this from happening. So very interesting. Reboot worked. I'm back. I'm here. So so good. We can get started. So sorry everybody. I'm late. I hope you're enjoying today. It is 3/14, otherwise known as Pie Day. I've got a little slice here, apple pie, and to celebrate that. So it's good that we could get together. So sorry about the technical difficulties. Not sure what happened with that. But you reboot enough times, so maybe it just comes back, and that's what we had. So good. We can get started. Tonson, have you got the slide, right? I'm going to let you run the slide.
Well, I thought what we could
If you
do is you
can.
go ahead and give your news update first, and then we'll start the slides.
Okay, perfect. Perfect. Let's do that. You guys have probably been discussing stuff without me while you're waiting me to get on.
Yes.
So very interesting. There's a lot going on this week. For those of you that have been following the news, actually the start of March has been packed. There's stuff going on every day. Monday, we had the end of the Federal Reserve lending program for banks, where they could borrow money against the assets they have on their books. And many of them are in a total panic at this point. That was the bridge of liquidity, keeping the banks alive, because they could always just borrow some if they needed it. That's now cut off. The other interesting thing is that when I was looking at this yesterday, Europe has had one of these funding programs going for about 10 years because their banks are such trouble. In fact, the European Central Bank was proposing to lower the capital requirements to make a loan down to 1% of the loan amount. Think about that for a second. So banks are in trouble, and it's not the US, it's everywhere. It's in every country. Japan, China, throughout Europe, the UK, that we are seeing the death of the old system. It's coming down very quickly. And we're going to see over the next week, could be some things that trigger by tomorrow, or it could be within the next week. So just keep your eyes on it. I'm not giving any dates because that's not a good thing for me to do. And my sources don't want me giving any dates. So just be aware that there's some things happening where the system will come down. Now, once it does hit that breaking point where it can no longer be sustained, it's going to be turned off. Okay. So there will be basically a governmental emergency broadcast that'll go out saying, we've turned the system off, stay in your homes, and while we get this resetted. So the reset, of course, brings in the new currency. It's going to be Treasury currency that they print. We're not going to use outside central banks anymore. And this is not just us, it's countries all over the world. So there's a lot about to happen. I mentioned in my last podcast it was going to be March Madness, and we've seen some of that already, but the next week is going to get even crazier. So hold on tight. We're gonna come into some very interesting things. I don't want anybody to get into a panic thinking their life's going to end or everything's going to be just a disaster, because that's simply not the case. There seems to be some evidence that even in the markets that are at-risk markets, such as the stock market and other things, we have a situation there where the new financial system is monitoring those markets, and they are mirroring, to the best of their ability, the retirement accounts. There seems to be an effort to try to shore up or save the retirement accounts. Everything else, if you're in the market, good luck. Okay. And I'm not going to tell you stocks to pick or not pick or whatever. There's just systemic risk that is very high at this point, and we're going to see more of that over the next week. Be careful with your bank. You may have a good bank. They may be fine. They may be in good shape, but there's going to be a lot that are not. They're going to be facing some problems. And with the liquidity faucet turned off to them, in other words, they have nowhere to go to borrow other than from depositors themselves. So that was kind of the final stopgap that has been in place for the last year, where now I think everything's ready for the reset. So they've turned off that, and now we're going to see the end. How quickly will we see this play out? Well, it could be weeks, it could be days, it could be tomorrow. The timing is pretty much up to, there's a very small group of people that actually know the timing. And that wouldn't be me. And I've been told not to discuss timing. I've been given some windows, but I'm not even going to talk about the window because I don't think that's helpful. Just as long as everybody is prepared, stay calm. This isn't the end of the world. This is actually the birth pains of a new world, a new, better world that's going to be beautiful. We're going to be discussing trust today, which is great because we're going to be launching projects very soon. And we need vehicles to help us with these projects. And more importantly, we need vehicles to help us save our assets and our newfound, in some cases, there's going to be some newfound wealth that comes out of the transition, the wealth transfer. And you're going to want to do things with that keep it safe and keep it protected. So we're going to have a lot of discussion about that today. I think the timing of this is actually really good because a lot of people are going to be facing this issue very soon. So I hope that's helpful for some of you as we get started.
Thank you, Will. So that's a brief update, and everyone enjoys your longer ones as well. So we'll look forward to having another longer one here in a few weeks sometime. But
Yes.
yeah, let's go ahead and have some fun with the trust topic today. And I'll start the slides for that. You have really appreciated it. You've had a lot to say about it. Randall is usually the one who teaches us, and he will join us a little bit today for that. But yeah, you have had a lot of insight into the wisdom of this trust design. And so we greatly appreciate that. And
Well, and I'd like to thank Randall for being here. There's other things he probably could be doing, but to be here and to be a knowledge base, we are going to do a Q&A at the end, and there's some questions that maybe only he can answer. I have a lot of great things to say about Randall because for 4 decades now, or maybe it's 5, I don't know, you've been at this a long time. You have been helping people secure their families, their wealth, their assets, taking care of things that are most precious to them. And I just want to thank you for doing that because your record is impeccable. And that's the reason why we're discussing this today. I do have one of these trusts. I'm enjoying the benefits of that. And that's why I'm so passionate about this. I think that everyone should know about the vehicles available to them. As we launch into the new golden age, if you will, I think you're going to find that the standard quota of corporations, which was a banker's construct, by the way, are not going to meet your needs going forward because you're going to need more flexibility. And I think that's what we're going to find that you can have with this today. So just in the beginning here, I want to thank you, Randall. Thanks for being with us today.
Most welcome. My
And I
pleasure.
wish I was on that beach with you. That looks beautiful.
Only a plane trip away.
Okay, we'll do it soon. Be great.
well, this is very strange. My keynote has disappeared.
I have a key. You have the note?
All right, let's try this again. All right, there we go.
Oh, it's working.
Okay, there's your bio. And let's go ahead with the first topic. Um, lead asset protection, learn the benefits of a natural law trust, and so on. So we'll just go through these and go ahead.
Well, I just want to make one comment about the benefits of these and that they've been around a long time. I first learned about natural law trusts when I was a banker, because I found out that the very wealthy were using these, and they weren't your typical off-the-shelf lawyer trust, right? Your typical statutory trust. That's what most people were familiar with. But what you'll find with this, there's specific reasons why the super wealthy were using these. And there were many reasons, but safety, security, and one of those was tax-free because it's not in the taxable system. And so you had wealthy families such as Rockefellers and others that had thousands of these set up so that they could do what they want to do and don't have to be taxed. The cool thing about these trust, folks, is that you're going to find that you can use them for any type of asset. Now, I'm not a proponent of a trust for everything, and I'll say this openly, because there are some vehicles that are probably better suited if you have something that's not necessarily an asset. What I mean by that is we're looking at airplanes here in the background with this slide. Is an airplane best put into a trust? The answer is it an asset or is it a liability? And the lines blur with something like this. You may be considered an asset because you could do things with it and travel. However, it's depreciating at such a rate that it may not necessarily be considered an asset because of the depreciation rate. So you have to be wise about how you utilize these things. In some cases, I would say an LLC or some other structure might be better for a depreciating asset because it's not necessarily holding its value. However, if you had a piece of real estate or something else that holds value long term, I would say that would probably be a great idea to use for a trust in that application.
And the main point here is that it works anywhere in the world.
Yeah. Comment, Will?
Yeah, go ahead.
Asset can be a liability. And so, yes, you would put an expensive plane into its own trust, not necessarily because of the depreciation, but you don't want that the liability part of an airplane or an automobile to run rampant and create an injury. And that's why you wouldn't put it in with another asset. So you would never put anything that can create a liability in with your asset.
And
As
if
long
you,
as you're clear about that, it's pretty clean.
I love that comment because you're right, because you're creating this cocoon around what could be a liability risk, protecting it from infecting anything else that you have. So
Right.
great point.
and so if you put it in a trust, make sure it's the only asset in that trust.
Correct.
Yeah. This
Can I make just one comment on this about
Yeah.
natural law trusts? We're talking about the most basic component of contract here. Why is a natural law trust able to be used anywhere? As you mentioned that, Taunton, any country, because it's really operating under the basic construct of being able to contract. What is a trust? A trust is basically a contract. A grantor contracts with a trustee to take care of a beneficiary. So it's really a contract in itself. What's different about that versus some other vehicle like a statutory trust is you go with a statutory trust, you're going to the state, county, or in some case, federal government, seeking their permission to exist. If you need their permission to write a contract, you're considered incompetent. Therefore, they need to be a party to your contract, which allows them to govern and control that contract. In other words, they can control what happens with your trust. This is why it's important as we talk about sovereignty that people understand a private contract in a natural law trust is a form of taking responsibility wholly for your life and those that you love and care for, in a way that is fully responsible as opposed to being incompetent.
You have a talent for making complex things simple and plain and easy to understand, Will. Thank you.
Oh, I love that graphic. Building the estate protected in the future. This is going to be great, folks. We've got how many slides here? 50 slides. So we're going to cruise through these.
Yes.
Because I think the Q&A is going to be a lot of the meat here. But the idea is keep it simple. With your contracts, and you're going to find here in the future, we're going to have things like, in fact, this was just launched on the Stellar network a week and a half ago, smart contracts, Protocol 20. Smart contracts was simply a way for people to contract with each other on the blockchain, and you don't need a lawyer. So somebody provides an asset, you provide money, you can contract that and close it. So we're moving future-wise into a place where we're doing commerce directly with each other, and we're bypassing attorneys and middlemen that actually just make everything more expensive. When you get that out of the way, you've got this is what's coming. So I like the graphic about protecting our assets into the future, because this is going to work so well in terms of a trust in protecting that asset, keeping it where you need it, using it the way you need it, and ultimately making that an effective benefit for the beneficiary. If you can't fully utilize an asset, then it's not being effective in meeting the needs of that agreement or that contract.
Yep.
Bridge to the golden age. Here we go, folks. We're going to be moving into a new way of doing things. The super rich have been using these for years. When I say years, not a few, hundreds of years. These type of agreements have been used. There are trusts over 300 years old and still going strong. There's no reason that you can't also do the same for your family and for your business or for your projects in the same way.
Just a note about that is that they're not written into perpetuity, but they are written for 21 years or so and then renewed. So if they're 300 years old, it can be renewed every generation. Yeah.
Yeah, and that's actually a good point to make, Tonson, because it's actually, you can't really write a contract to perpetuity. That doesn't really meet within the laws of standard contract. There should be a duration.
Yes.
And so by specifying a duration, it doesn't mean that it's held to that. It can always be renewed and renewed for another term. So as long as you keep renewing it, it keeps going. Thank you.
Yeah.
Will, there was a comment on the church trust, the religious trust. It can go on in perpetuity because behind the charitable purpose is the Attorney General of the state has the power to activate and make the trust happen. So in other words, even though there's not a named beneficiary to a charity, to a charitable trust, it can be made to happen for the use of the Attorney General of the state where it's located.
Great.
So
And we might talk a little bit later about how the trust is similar and maybe different from corporate souls.
Right.
Okay.
Understand. But the concept is that you have it validated, and it can either be on a 10-year basis or it can be in perpetuity depends on how you set it up, but you're right. You want to have it so that it's a renewable process. Keeps everybody on their toes.
Yes, it does. Thank you.
We can breeze through these that have a lot of words on them.
Let's talk about this one for a second. You can be the trustee or appoint trustees of your choice. This is the best trust in the world, proven by at least 5 generations of time experience. As we just talked about, it can be way even beyond that. Here's the neat thing about this. In some situations, you know best what that asset needs to be used for. What I mean by that is, let's say you're the parent and you're trying to help protect your children or even their children's children, right, to other generations. Who better knows how to fulfill that experience for the children than the parent, right? So in some situations, it's preferable for you to be a trustee rather than the grantor that contracts the trustee. And in that case, there is flexibility with these types of contracts because you could have what's known as a nominee grantor who can help you fill that role. You still need each of the parties, but you could do that as the trustee versus the grantor. So there is flexibility in that. And I really like that aspect of this.
Very much so.
I think, Randall, you're one of the only trust writers in the world that allow and encourage unless you're too young, like below age 21, or too old, you want to be your managing trustee. Yeah.
Well, yes, it depends on your status. And if you've been working for 50 years, you might want to just be the beneficiary and let somebody else take care of it. You basically help them set up what you want to do, how you want to invest your portfolio, and then they take care of it. And if you're younger and you're mid life and you want to run and be the trustee, then you should be able to do that too. And we have that choice. We've set it up so that you can have a nominee grantor and be a trustee, and the trustee can put funds into the trust. We also have it set up so that you can just be the grantor and the beneficiary. So we have lots of options.
Yeah.
Excellent. Before you change the slide, Tonson, I just want to read this last part of it because I think this is very important. It has no requirement to be approved by any government and has a 100% success rate. This means that it's never been penetrated. It's never been invalidated. In fact, cannot be invalidated. This is because it's private contract, folks. You don't, in most cases, contact your state or your senator or your local representative and ask their permission to write a contract to put an addition on your house. In fact, the idea would be absurd, right? When you write a contract with a contractor to do certain work, that's between you and him. Okay, that's really all this is here. You're writing a private contract to take care of a beneficiary. And so the government's not involved. They don't have any jurisdiction in a private contract. And this means you don't have to worry about them trying to get involved and tell you what you can do with it. It really is individualized to each of us. Thank you.
Good point. Excellent.
Protect your assets now for future generations. I love that. What is an asset? An asset is anything that brings benefit and happiness to you and your loved ones or those that you work with. So anything can be an asset as long as it's something that brings a benefit to you or your children. It could be money. It could be houses, cars, physical assets, any of those things, as long as it brings a benefit to you. So anything could be an asset, and you can really wrap a trust around any of those things to provide some protection. Interesting thing about protection is that, and we talked a little bit about liability. Liability protection is a big deal. If you have something that, particularly something like an airplane where there's possible risk to human life, you obviously have some issues there. Because if somebody wanted to sue the owner of the plane, and use that for example, they're going to have a hard time getting your other assets if the owner is just the trust, right? They may sue that trust, and the trust may turn itself over, but they're not getting anything else. And so that's the idea of being creative with how you isolate risk and manage that. And this vehicle is perfect for just that scenario.
That's a good way of saying it. Isolate risk. Yeah.
How to ensure your wealth goes to your loved ones. I want to talk about this for a second because I've had experience with, if any of you have had experience with probate, you probably know what I'm talking about here. Probate, it happens when someone passes away and they don't have a means of transferring the assets that they have to the next generation. So it's taken up by the courts. Now, there may be a will, and a lot of people, and actually many television programs actually promote this. Oh, everybody needs a will. A will may state the desires of the deceased, but it doesn't necessarily say anything about how the assets utilize. So what invariably happens is the courts take over the assets of the family. There's may even be fees involved in that you surrender as a part of the process. And they may try to fulfill some of the desires in the will, but you're putting your family's wealth and assets into the hands of the court. With a trust, there is no such thing that occurs. It can be passed directly to the next generation with zero issues. There's usually no issue with being able to use those assets continually. In my own family, I had a situation where one parent died, created a problem. There wasn't proper structure being done. And my mother, who survived, decided she didn't want to do that to her children the way it was handed to her by her husband. So she formed a trust and put everything into that so that there would be a means of the next trustee, if something happened to her or someone else, the next trustee could take over. We had a very seamless process. There was no probate. The assets remained in the family. And it was such a stark contrast. It really got me moving in the direction of trust more when I realized we had just saved enormous headache and money by being able to be properly structured. So think about this, folks. The natural law trust is, I think, the most perfect form of trust, but being able to keep that in your family and not worry about the courts attacking it or getting something out of it is a big deal.
And then there's the story of the billionaire Hunt brothers in Texas. One of them died. The other was the successor trustee with a non-statutory trust like this. In the newspaper, they reported that they couldn't figure out what his net worth was because it was hidden, but they knew it was in the billions. All they could find in his name was $5,000 in cash and a pickup truck. And so, but his brother, who succeeded him, seamlessly became signatory on his assets the very same day or next day. No probate, no death taxes, no attorney fees, no court costs, nothing.
That's beautiful. I love it.
Gotta have it. Gotta get rid of probate.
Yeah.
Get it. Natural law trust. You won't have any deal with probate.
So this section talks about the attorneys, and we just have a cute caricature here to illustrate.
I resemble that remark.
Well, it's interesting, and we're moving. What's interesting about the reset that's about to occur, folks, is that we're moving into Jezra, where there's going to be adjustments made to our legal system. I don't know about other countries, but here in the United States, we're actually operating under the British bar registry. That's what the bar is, British
Accredited.
attorney registry, right? Accredited registry, excuse me, British accredited registry. So every U.S. attorney that's operating under the bar is actually operating under a foreign jurisdiction, which is in the UK rather than the United States. And most of the judges are all part of that as well. So we have this weird scenario going on. A lot of people are starting to become aware of this and how this affects us. The cool thing is with this type of trust, you bypass all of that by writing your own private contract. And it's perfect.
Yep.
Serves all beings always perfectly and equally. I love that. Unless you have something unequal written in your contract, but most don't want to do that. So I love it.
Yep.
Natural law versus statutory trust. We've kind of been talking through this a little bit, so I'm getting ahead of myself here probably. But in a statutory trust, they're almost always written by attorneys. These are bar attorneys. They're using various signatures to validate those contracts. They're recording it with the county courthouses or federally. And so the government and the attorneys are involved in everything. And so you're bringing outside influence into what should be a private matter when you're using statutory trusts. Statutory doesn't necessarily mean lawful. It just means it's a statute. Statute could be anything, doesn't necessarily have to even be lawful or legal in some cases. So you can bypass that by staying away from those situations that could really get you into trouble. And I've known many trusts, the statutory trusts, that were busted into pieces when people came digging for assets under a situation where there were lawsuits flying around, and in some cases people got hurt or even killed in accidents, and then they go digging into the assets. If you've got a statutory trust, it could be broken. I'm not saying it will be, but you run the risk of it being broken. Natural law trust is private. It's between you and the trustee. Or if you have a grantor trust, nominee grantor, excuse me, then it's between that grantor and yourself. No one else is involved in that. Even the beneficiaries themselves may or may not know all of the details of the trust. It depends on whether the trustee feels it's important to do that. So we'll get into some of that a little bit later.
Throughout history, in the last few thousand years, it's known that the more laws a country accumulated, the closer it came to oblivion. And when the country had just way too many laws, it crumbled and collapsed. Today, we have millions and millions and millions of statutes. In fact, I heard years ago, there were 3 million law books in the Library of Congress. No lawyer can keep up with all of that.
Yeah.
And they're changing every year. Every time Congress passes something new, they change.
And here's a good example. Recently, there was a illegal alien, person that crossed the border illegally and murdered a woman. It was the student in nursing school, Lake and Riley. So this has been on the news. It was even brought up in the State of the Union, thanks to Marjorie Taylor Greene. She really made sure that that was brought up. But it was interesting. They're now trying to pass a law to protect people like Lake and Riley. Is this necessary? No, it's not, because the law says that you shouldn't be coming over the border illegally. That's already on the book. So it's redundant to have all these little specific things that really are not even necessary. So good point. Natural law trusts protect investments more effectively. Children and family members can be the successor trustees. This is a big deal. One I didn't realize until I got some education from our man Randall here to help me learn how this works. So if let's say you have a family trust and your children are beneficiaries of that, but you want to set up a situation where one of them may take over the family trust because maybe you feel like they're maturing appropriately where they could take that responsibility, you can set that up. But I think the whole key is that that it's done properly, because you cannot be a trustee and a beneficiary at the same time. That kind of breaks the three-legged stool. So, you know, Randall's probably better one to tell you about this, but basically there is a process how a beneficiary could surrender that benefit in order to take another role, which might be a trustee.
I'll talk about that later, Will.
Randall, if you want to turn your video on, we're going to ask you to comment on a few of these here.
Magna Carta in
I gotta go
2015
get
and the
my makeup.
Crusades. Knights and barons needed a way to keep their estates, beginning with trusts. Knights began to leave their estate and the church of friends while they went off to fight. So during the Crusades, you'd have owners of property, sometimes vast estates, that would join the Crusades. And they wanted to make sure that somebody didn't steal the property while they were gone. So they began creating these trusts where someone would take the role of a trustee to care for the asset in their absence until they returned. Some cases they returned, sometimes they didn't. So this was an important part of securing the assets for the family. There's some history there.
It goes back beyond that. Actually, finding how that the Romans actually developed a trust law, and the wealthy Roman society had all of their property in trust. So
That's an interesting.
It's even older.
Sure, it goes
That
way
doesn't
back.
surprise me at all, and I'll bet it goes even beyond that.
Sure. You have a contract. You
Yep.
spit in your hand, you shake your neighbor's hand, and you say, "I'm good for my ward," and that's how it works. And if
Yeah.
it's not, then that's what gets you in trouble.
Yeah.
Oh, I love this. 1620, the
boy.
Pilgrims, the first immigrants to America, brought the idea of trust. The land was free. The owners needed a way to protect it from the king, which was the government at the time. There's a lot that occurred in that time. My first ancestors came here in 1630, so 10 years after the Mayflower landed. And they actually used some of these vehicles. They fortunately were not preserved. They were broken down over time or were not renewed. But yeah, some of this was done in those early days.
I think I can see traces of Homeland Security already in 1620.
Yeah, you're probably right.
That was the good kind.
Early American settlers did not want any statutory entities. The government already had its fingers in the pie. So you had Tea Party and American Revolution. The people wanted freedom. The U.S. Constitution states those first 13 colonies had that right to contract that it shall not be infringed. This is why it's an important part of the Constitution and the Bill of Rights. The Constitution had trouble getting ratification until they included what we know as the Bill of Rights. When that became a part of it, that's when full ratification occurred. And of course, those protected us. Those were very important rights. And that was a big deal. In fact, it's lasted 200 years. We are going to celebrate here in 26, the 250th anniversary of this nation. I don't know many, if you look historically, I don't know many governments that even existed anywhere close to that length of time. So an amazing thing that's occurred here.
Yeah.
Now, I just want to make one comment. This isn't, the right to contract is not unique to America. So If you live in Australia, Canada, or any other country, the right to contract has been protected in almost every single country on the planet. So this is why a natural law trust is useful, because it can go into various jurisdictions as long as they protect the right to contract. And this most countries do. In fact, it would be crazy not to do it. So
It's reflected in the Uniform Commercial Code, which is global.
yes. So this is based on common law. Big deal, because we're not talking about bar here. And the natural law is always kept private. It's the law of the land, and the law of the land can be deduced to one thing, two things. Okay, first, do unto others you'd want done unto you. There's the first one. And secondly, do no harm. As long as you don't do no harm to another, you can live fairly free.
Yeah, and keep your agreements.
We already talked a little bit about this, about them being private. They can do any action a person can do. This is pretty cool, because if any one of you can perform a duty to do anything in this world, and it could be a mechanic working on a car or anything else, a trust can provide the same service. So you don't need an LLC or some other vehicle when this actually can function in all of those capacities in terms of providing a product or service. So I love this. I like the education that you've done, Tonson, over the years in this regard, in helping everybody understand that we don't need these complicated statutory structures. Those were all designed to lock us into chains, into the system. Really, we just need to be smart and enter our contracts knowingly on our own two sovereign feet.
And this slide refers to Randall talking about my mentor.
Yes, I was really fortunate. This gentleman from Sacramento had been writing trust since in the 50s, and he had polio as a child, so he was in a wheelchair mostly, but he was pretty much of a savant around trust law. And he just came in and he said, okay, see those 27 volumes over there, that's your first assignment. And then, of course, he was throwing things at me as I tried to read each book. But ultimately, he just said, look, this is how it works. Let's boil it down to the simple principles. You're going to write a contract with somebody. You're going to say, what do you want to do with it? You're going to get an asset to fund it. And then you're going to have a name of a beneficiary. And then it's done. It's a done deal. And you go about your business. And you can't beat it. So go for it.
Yeah, it's fantastic. And I had a couple of people ask me the other day, they said, well, what if you want to provide for your family, but they're not yet born? In other words, you want to provide for your children's children, right? Maybe they're not married yet or haven't had any children yet, but you want to do that. Well, that's easily done, because a trustee can form additional trust to care for additional beneficiaries. So it's all doable within the construct of the private contract.
Correct.
They made you study 27 volumes.
There was an array of books on the shelf. I'll just say that. Whether it's 27 or 30 or 60.
Yeah.
Anyway.
You've studied many since then too.
And it's in Will, as you said, this in Tonson, you iterated, the statute is consistently new statute, new statute, new statute, new law. And so how do you keep track of it? In fact, if you're involved with any of this, the stuff you get from the court, where they send you updates of every aspect of what you're studying, you're looking at having to replace 10 pages a day in your book. And so it just gets to be a burden rather than a joy. And so you just go back to the simplest form and say, I go to the client, I say, what do you want to do for your kids, for you now, for your kids when you pass, and for the future generation? And they're really happy with the fact that the natural law trust can do that.
Yeah.
Yeah, and I think the, you know, good component of this is I have a friend whose their father was a successful businessman, and he wanted to take care of his family. And he went and he wrote one of these, had one of these statutory trusts created, but he was worried that one of his sons would be frivolous and not do things proper with it. He was worried about some other child would do something. And so he wrote all these contingencies. This trust was over 500 pages
Unbelievable.
of contingency situations. And I will tell you, knowing this family, it has become the most burdensome piece of document they've ever encountered. It's like they almost can't do anything because they're running into all these issues. And when it could have been simple, he could have just said, trustee, use your discretion.
Yeah.
Here's the intent I want followed, but use your discretion in the moment. And it could have been simple, but they made it
Excellent.
complex.
Excellent. Use your discretion to carry out the intent of the trust. That's perfect, Will.
Yeah.
Right on.
The natural law trust ensures that your wealth doesn't get caught up in expensive and private invading process of probate. We discussed that. It makes a will less important or redundant. It makes all restrictive statutory forms of asset protection unnecessary. You can still have a will. In fact, the will could even be private, given just to the trustee, because really it's all about fulfilling the intent of the trust, right? It surpasses the entire field of statutory and non-statutory entities out there. In other words, I've had a number of people present to me what they called common law trusts, but really they were just a statutory trust with a common law label stuck on it, because they were still caught up in the same construct of the legal system, which is, again, legal. And people, you do your research on this. I have. Legal doesn't always necessarily mean lawful. Okay, those can be different things. It has corrected mistakes made in other methods and given generations fortune operators the pleasure of quietly remaining protected and remaining private and free. This is an interesting component of this. There is, even if a trustee were to be summoned to a court, if the trust says that the information must remain private, the trustee is under no obligation to reveal anything to a court or any other entity. Otherwise, he breaks the trust and therefore would not fulfill his contract as a trustee. So it's very simple. He could just simply say, I cannot answer that because that is in violation of the trust.
And furthermore, the jurisdiction can be only very limited to just certain transactions. No jurisdiction can ever cover the trust itself, but only specific transactions.
Yes, typically in what a court case would be a breach by the trustees for a wrong action or a wrong action against the trust, in which case the trustees have to step up. So it's really, really good about that. That's a really, really good point. That can only attack the injury if there is. Otherwise, I'm sorry, that's all private.
Right.
Right. Let's look at what the trust can do, because I love this part at the bottom. It can hold bank accounts. It can pay bills of trust officers and beneficiaries. I'll add that. It can hold real estate. It can protect just about any kind of asset. The type of trust can be a foundation, either to receive grants or make grants. So you can, very flexible in that regard. It can hold businesses. It can hold the scientific institute. It can hold religious or spiritual organizations. It can be a holding company. This includes even IP information. It can be a family estate or planning instrument. It can be a personal vehicle for commerce. So the trust could act as a business itself in buying and selling. And it can also be a tax shelter. The reason for that is the fact that a private contract, because it's not statutory or needs the government approval to exist, it exists outside of the system. It's not in a taxable system. It's actually outside of it. It is private. And I'll make this one comment, and I learned this myself when I was studying some aspects of law. In the 5th edition of Black's Law Dictionary, I looked up the definition of owner and what it said, and I thought it was very fascinating. Now we're on a much later edition now, if you looked at the current one, but it said an owner means that you have a right to decide if a thing is taxed or not taxed. So if you don't have that right to decide that, you're not an owner. Think about that for a minute, people. If you want to be sovereign, you use these private vehicles. Keep your stuff to yourself. So. The 3 secrets. Trust has to be private, not statutory, has to stand up globally to every hierarchical law, and it does that because it's under the right to contract. It has to have no filing requirements, okay? If you have to file for any reason on a yearly basis, you're in their system. They'll tell you what you can do and not do. Prince's estate is reportedly worth 100 million to 300 million, and the court is charged with dividing up the estate of Prince, the pop star who died in 2016 without a will. Of course, even better than a will would have been he had a natural law trust. Isn't that amazing that an asset that's that big would just be handed to some judge to decide what he's going to do with it? I have heard judges, and I've been in courtrooms where I heard this specifically come out of the judge's mouth. Well, we will administrate this payment. It'll be handed through the court. We will charge a 5% handling fee for doing that. And everybody had to agree to it. It's unbelievable.
Oh, many estates have had as much as 50% of the assets disappear to courts and lawyers and everything.
And if you think they don't end up in the personal bank accounts of judges and other people,
yeah.
you'd be wrong. Assets protected 100%. They are protected from creditors, from liability suits, malpractice suits, employees, personal bankruptcy, even sticky divorce situations. Avoids probate, inheritance tax, estate tax, and court actions. Eliminates attorney fees, executor fees, income taxes. Eliminates or reduces accountant fees. Frees tax dollars for capital appreciation. Provides complete control over your assets through trustees. No public record. Ownership and title can be passed to heirs in a complete private and secret manner. It can be renewed every 25 years. Heirs cannot change, challenge, or contest any wishes at the death of maybe the grantor. The trust is easy to maintain and very inexpensive. Of course, there is an ebook that Brilliance of Commerce has. I suggest everybody get that and read it. Thompson, you did a great job with that ebook. I thought it was very well done in explaining all the components of this. So if you go to Brilliance in Commerce, you can find that ebook on there. International recognition of this trust's right to exist. Oh, I love this, but I want to hear from Randall on this because he's had some experience with this.
What would you like me to tell you? It's absolutely true. That first
You've had clients in different
sentence says it
countries.
all.
Yeah, you've had clients in different countries, and you've not seen any issues at all with this, correct?
They may call it something different. In other words, in some of the countries, they won't entertain the word or the dynamics of trust. And so you have to just have to say, okay, what is it that that country needs? In some countries, they just want an interface. So we create, like you talked about earlier, the potential of having an LLC or whatever little local entity allows them to feel like, oh, okay, you're in our ballpark now, so we can do that. But that LLC or whatever the entity is of that particular country can be owned by the natural law trust. So we'd say, okay, let's not go in the front door. Let's just go in the back door, give the government what they want, and then we'll have that subtle control as we should out the back end.
Yeah, and I love that. And the reality is the right to contract is upheld in almost all countries. The problem gets in when you're trying to conduct business in some of these countries. They want to feel like you're in their system, right? But you
Well,
can
you're
have
an
you can have a
alien.
face, an LLC is a face, but you don't necessarily need to put all the assets in that, of course.
Right. You keep your assets out of that storefront. The storefront is your public face. That's what I call it. I say my storefront. The storefront is your public face, and so that's what you want everybody to know, especially if you've had a business already. Like a lot of clients come to us and they've had 5 or 10 years out, out in the public. And so we create for them a way to keep that public face whole. And so it doesn't have to disappear. It doesn't have to change its name. It can, but it doesn't have to. So they keep that. And so in order to keep it alive, they use the local entity, local jurisdictional process. And then that process is ultimately owned by the trust. So it gets back that way. So you can do it. You can go pretty much anywhere that you can shake somebody's hand.
I think it's perfect. And the cool thing is as we get into Nezra Jezra law that's coming, that's going to roll across the world, it's going to even be easier to facilitate these things, because we're not going to have some of that construct that gets in our way now. So
Yeah.
thank you. Politeness. I love that. That is so perfect. If you are polite to everyone, if you're a good citizen and you do no harm, you're probably not going to be sued in the first place.
Well, the point here is a lot of the so-called common law trusts have all this very vile anti-government language in them, Mr. Bureaucrat, stay away, and we have our rights, and we're stand on the Constitution. And, it's almost like the text is, don't tread on me with a gun pointed at them. They're not very polite. You walk one of those into a bank and they'll say, no, thanks. you know, Randall's trusts are written politely. There's no need for anti-government language. We're not anti-government, just
No.
because it transcends the requirement to comply with statutes doesn't mean we have to be against anything. So these trusts, you're proud to walk into a bank, and they're polite, they're cordially written, and the banker is usually pleased. I mean, they'll smile and say, fine,
Either that or it confuses them quite a bit. That's the
Yeah.
other obstacle that we have to overcome, is we have to educate the banker as well sometimes.
Well, that's true.
Walk in bearing cupcakes,
Yeah,
be nice.
exactly. That's a good point, Will.
Yeah.
You walk into a police station with a dozen donuts, but you walk into a bank with cupcakes.
There you go.
The squishy ones, so they don't make any noise.
Right. Transcend all geographical jurisdictions, and the right to private contract is absolute. So yeah, we've talked about this a lot. So we'll scoot past this.
Yeah.
Who's who in a trust? Okay, this is actually important. We should probably talk about this. I want to keep it simple though, because I don't want anybody getting confused about this. A trust is a contract. The grantor, as you can see on your left there, the grantor is contracting with the trustee, so private contract, to take care of the beneficiary. Simple, simple. Just keep it that way and you won't be confused. Later, if a beneficiary is wanting to or is able to, or the trust is probably up to the trustee, take on a role of a trustee, a beneficiary can then have a role change. But you cannot be both of these or two of these at the same time. There is one exception. I think a grantor could possibly be a beneficiary after the contract. Is that maybe the only
That's correct.
exception?
It can be, yes. Yeah,
So,
grantor
but
can
other
be.
than that, you're one or another. You're not. You can never be both
You
of
can't
any of
be,
these positions.
you can't have 3 hats. You can have 2 out of 3.
Yep. So if you want to be the grantor and you've got somebody that's going to take care of everything for you, you can then be a beneficiary. You could do that. So that's just one example. So.
And you're gonna have at least 2 trustees. So I always say it's like a table with 4 legs. You know, you have to have a minimum of 2 trustees, 1 grantor, and 1 beneficiary for the table to stand up.
Yeah, and you'll find as you go into banks and try to set up bank accounts and stuff, they want to know there's a backup trustee and who
Right.
that person is. So that, in fact, that's a requirement pretty much on any financial institution. Who's the backup to this if something happens? The
Right.
trustee.
Successor, right. Who's
Yeah.
your successor?
Okay, so we can do all kinds of things with a trust. It can hold all types of things. In this case, we've got cash, mutual funds, real estate, bonds, stocks. Any of those can be held by a trust. The grantor, if he is the owner of those items, can grant them or convey them into the trust to start it, right? And then the trustee would take over the management of that. There were always, in this case, beneficiaries. Beneficiaries, even though they exist, there is not any timeline of when they must receive the benefit. That is completely up to however the grantor wants to do it, right? He could have it paid out at certain intervals or at the end of, some trigger point. It could be anything.
As long as the discretionary, the word discretionary is in the instrument, then the trustees have discretion. Some trusts are written so that the trustees must give out so much per year or so much per person. So it just depends on how it's written.
And how it's written is really up to you.
Yep.
Okay, how you want to do that. I just in my years around various instruments and vehicles of business, I find that a discretionary vehicle always is better because you don't know what may come at you. Like, let's say you've got a trust set up, take care of your children, and something happens to them. Maybe one of them is in a car accident and somebody else dies. And now you've got somebody coming after a beneficiary. Well, you want to make sure they can't get to the assets, right? Another scenario might be maybe it's the beneficiary that gets hurt and now they need long-term care. Now, instead of living on so much a month or per year, now they need additional care because it's going to be a long-term situation. Well, if you have a trustee that you trust, or maybe you are the trustee, you're going to know what's best. So if you have discretion within your contract, then the trustee can make those decisions to the best of their ability to meet the intent of the trust. So I think that keeps it simple and it actually reduces the pages. You don't need that many pages as long as you have the ability for a trustee to do their very best to fulfill that agreement.
Yep.
Okay, you can be a co-trustee with an unrelated co-trustee. I want Randall to explain this one because there is some flexibility here. So let's talk about the flexibility.
Yeah. The choices are really good. the first, basically when I first started, we as trustees, we were the trustees for the client, and the client just wanted to be the beneficiary. So as long as we gave him a check every month, he was really happy. So that's how you can do it. But the idea was that either if you are a client, then you need to have a trustee. If you have a family member as a trustee, then you need to have a non-related co-trustee or a non-related successor trustee named that can take over if something happens. Now, if you want to be a trustee and a beneficiary, you can do that as well, as long as you have, again, an unrelated second co-trustee, and as long as your beneficial interest is less than 50%. I've done a lot of research on that, so 50%
Mhm.
or less, if you're, then you're considered a minority grant beneficiary, and you can receive that amount as long as you've stated the possibility of a conflict. So there's some caveats in there, but basically, yes, you can do that. And then you can be a minor beneficiary. So as long as if you're going to be a co-trustee, you need to have a secondary co-trustee unrelated to you. And then if you want to be a beneficiary, it has to be less than 50%.
And there's even another option, and that is, let's say that you wanted to be the trustee, but you didn't want to give up your beneficial portion. If the trust is written where the trustees are allowed to receive compensation for their service, then there's really no, you're not giving up anything to be a trustee. You can still be compensated for the work that you
Right.
do.
Right.
So yeah.
And the trustee can put assets in and take assets out.
Correct. Yes, as long as we know beforehand when we're going into this, how we want to set it up for the client, like Will said, as long as that information is there, we can write it and have it the way we want it that serves the client.
Yeah.
If a client chooses herself or himself as the sole unrelated trustee, he or she must have a successor trustee. And I talked about that with financial institutions. Banks don't want to open an account for a sole trustee. If anything should happen to that person, they need to know who's going to take control.
Right.
It's just a good practice to have that, regardless of whether you're talking banks or otherwise. You don't want to leave assets in the control of somebody that if they die, there's no one to take over. That would be an irresponsible thing to do.
Right. And then it would go to the courts, and that's what you don't want either.
Yes, definitely.
Most people have just a couple of trustees, but if you're a big organization, you could have a whole board of trustees if you want.
If you choose.
Yeah.
The client can be trustee with an unrelated co-trustee and a minor beneficiary with a nominee grantor. This is interesting because one, if it's just you and you have someone you want to care for, or maybe that person could be any age. In this case, we're talking minors, so they're going to be under 18. That's possible to do. You can just be the trustee and you can have a backup trustee by just using the nominee grantor. This is what's unique about this, is not many people in the trust world talk about nominee grantor, but in this case, it helps to keep the trust intact, because if you break some of the rules here, you're going to have a hard time for your trust being upheld. But
Yep.
if you use the nominee grantor, then you can fit that role as a trustee very easily.
Yep, and the nominee grantor can basically disappear. That's a uniqueness of that aspect of it, is if you choose a nominee grantor, once you've signed 4 or 5 different schedules, then they're gone and you'll never hear from them again, because it's just you as trustee and the beneficiaries now. So there is a good concept in that ability to have a nominee grantor and you be the trustee. And again,
Yeah,
it's
and that's, I think that's a good thing to understand is we are talking about irrevocable trust here. So
Mhm.
not any other style. This is irrevocable. So once the grantor puts the assets into the trust, he's now no longer responsible. He could walk away. It's no big deal.
Right.
So we've got some people here that shows different roles. So there's a lot of flexibility. That I think the bottom line is, I think if you want to keep it clean and you don't want there to be anybody question the veracity of a trust, as Randall said, you could be two of those. So maybe you're the grantor, but the moment you've granted into the trust, that rolls over. So now you're just a beneficiary, really.
Correct.
Okay, in terms of long term. There, it can be a real sticky situation if you're trying to straddle between a beneficiary and a trustee. And I think that's, I just prefer that you don't do that. I guess you
Agreed.
can in a minor situation, but I think that you open yourself up to scrutiny, if you're not keeping it clean.
I'd agree, Will. I definitely don't encourage it, but it is available.
But there's, it's a situation where there's so much flexibility how you can do that as long as you stay within certain standard rules of trust. And
Yeah.
uh, I love these trusts because you can do anything with them. You can run a business. You can just be a holding company. You can hold individual assets with them. So there's all types of things you can do. And you can even create additional trust. So I want to make this clear. Let's say that you want to be the trustee because it's your baby. You know what's going to happen with this trust and how you're going to care for the beneficiaries. Let's say you have a grantor nominee, and I'll just use an example. And that grantor nominee puts in $50, okay, to start a trust. That's assets in the trust, right? His job is over. You could even pay him for the service if you wanted to. Okay, that's up to you, whatever you arrange. However, a trustee can bring assets in. So if you are a trustee and let's say you're sitting on various assets, and I'm going to use an example that's kind of relevant at this time, which is maybe you've got some currency that's going to revalue and you're wanting that to go to your beneficiaries. Well, you as the trustee, you could bring that in and you could convey it into the trust. You don't have to be a grantor to bring that in. Okay. You could set it up with a nominee grantor and still bring that in. So that's just one example of how you could bring assets in and you manage assets within the trust. So hope that's helpful.
Yeah.
U.S. courts and precedents have validated the rights of a private contract for a trust organization. And these are all the references in various court cases where that has been upheld. There won't be any issues, particularly in most of the Commonwealth nations or even the United States in terms of that. Private contracts are being upheld everywhere. So
Yeah.
I don't want to spend too much time on that. Simplicity. Gosh, people, I couldn't say this more. Don't be like my friend with a 500-page trust that's just a gargantuan nightmare, okay? Keep it simple. It's just so much easier. Get a trustee that you actually trust. I mean, that's why it's in the name. It's there for a reason. It should be somebody you trust to actually fulfill the intent. So in some cases, that's going to be you. Only you know really what that is, or maybe some other family member will success you at some point. But as we just saw in a previous slide, it's good to have a non-related co-trustee. Doesn't mean that trustee has to be active. Okay. But you want somebody there that provides that unrelated. That's what keeps the trust clean. You've got a unrelated co-trustee. If you want to have another person take over your place as trustee in the future, that is a family member, that's still okay, as long as you've got that unrelated co-trustee. Do they need to be involved? They don't have to be. They just need to be there on name to be a placeholder for you. So just hope that helps.
If I may comment, most
Yeah.
people who are not experienced with the natural law trust assume that it's so complicated. It's rocket science. They're going to have to rely on an attorney or some expert, their eyes glaze over. They're intimidated by the complexity. And the statutory professions do it that way on purpose in order to justify their professions and their fees. They put way too many words into the trust. They put a lot of legalese that you don't understand. You have to look up in a law book, and they keep it that way on purpose to justify their fees. And Randall, in his wisdom and genius, deliberately simplified it so that anyone with a high school education can understand it. And guess what? That empowers you as the client, as the creator, and especially if you're the managing trustee of your trust. It empowers you because you can understand it. You don't need to rely on an expert. You can manage your trust yourself. It's like driving your own car.
Mm-hmm.
You don't need a chauffeur. You don't need someone to drive it for you. As long as you can trust yourself, you're good to go.
Yeah, let's cruise through these. I want to get to the Q&A, and we've only got we got limited time tonight. So so we've
These-
covered a lot of this. So
This on the
let's scoot
website.
past that one.
And
Yeah,
the
it's
ebook.
on the website as well.
This is
Um,
the the fact that it can go generation after generation without, constantly changing statutes.
yeah, it can just be renewed and
Yeah.
kept going. Yep. Open a bank account. Yep, that's all possible. Done it. Most countries, a business member will be assigned to the trust from a government for opening a bank account. No problem with this. It causes no compromise to the privacy of the trust. In some situations that's required. In the U.S., it may not be, but you may be required to have a tax ID number or an EIN. In which case you can get one of those even for a private trust. You can still get an EIN for banking purposes only.
Pretty much in the US, you'll need to have an EIN number.
Yeah.
Yeah, and I think it's most other countries have something very similar to that. Spendthrift clause, this, if you're worried about some beneficiary might do something completely unresponsible with large amounts of money, you can always have spendthrift clauses in there. Again, I would say give your trustee the ability to monitor that and to maneuver. Because if they've got the discretion, they can do things appropriately with it. Thank you, Brilliance in Commerce. Just want to say that for all that you've done. Thompson's been working at this for years, and we've been working with Randall for many years. And I'm just happy to know both of you and to be a participant in these types of vehicles.
Well, as one Hollywood star said, it's mutual, I'm sure.
Fellow Trusketeer.
So how can you get one of these trusts? Well, you can go to, here's a web link there at the bottom, EnochNaturalLawTrust.com. That's a link that we've set up so you can get right into the trust. You can find a way to get started with your own process and have a trust written for you that's specific for your private and personal needs.
For those who are calling in by phone, that's Enoch, ENOCH, naturallawtrust.com. or if you're listening to this as a playback while you're driving in the car.
Right.
So
Good
the real
point. So,
price for millionaires and for the original and purpose and intent of asset protection for millionaires and high income people is $10,000. So we actually have a separate website for that, but there were so many more people who couldn't afford that and who still needed a vehicle for asset
yeah,
protection.
and I want to make one comment about that. If you are doing a comprehensive asset protection plan with any law firm in this regard, you're paying close to that number anyway. Okay. So there is a lot of value here, and we'll show that on the next slide. Here's a great opportunity, folks. Activate, ready to go, $2,500. So a fraction of what it would cost you. And you get it customized to you. So EnochNaturalLawTrust.com, click that link and it takes you right where you need to go to get that process started. Once you have made payment, then you would work one-on-one with the trust writer. In this case, we have him on. It's Randall. You're going to be working with him directly, and he will write this according to your specific needs personally. So you're going to get exactly what you need for your situation, and with all the flexibility we just discussed.
And that's a one-time lifetime fee. There are no annual fees, no further fees.
Yeah, there's no, and this is a good point. I have a friend that's got a couple of trusts that are statutory. He's paying money every single year to renew them
Mm-hmm.
and keep it going. It's unbelievable. And it's not cheap. In some cases, it can be as much as $1,000 a year, continual. This
And
is a
what
one-time
happens?
thing. You write the contract and you're done.
What happens if he doesn't pay the fee? Does he lose his assets?
They literally will take away his right to exist. Yeah.
Wow.
Yeah. They literally will shut the trust down and you can't even operate it.
Jeez.
That's the problem with getting involved in the government is it isn't just the control. There's also this money component because they want to be paid.
Yep.
Unactivated, first few pages created. This is for those that maybe they don't have 2,500 right now, but they want to kind of get started on something to help their family. You can start with this. You're not going to have a completed trust with that, but you can continue to make payments until you fulfilled all of it and get it completed. But you can at least get something started. Okay. Okay. I love this. Eggs in many baskets. This is important, and I want to emphasize this. If you have various assets that particularly have a liability component around them, or they may be a possible risk of liability, you may want to isolate those into separate trusts. Okay. You may need a particular, we used the airplane earlier, but an airplane is something that where there could be some bodily harm if it completely malfunctioned and fell out of the sky. So you'd want to isolate that into its own trust so that it's not affecting any other assets which you may have, which could be a house, a car, mutual funds, retirement accounts, any of those things. So eggs in multiple baskets. Thank you. Full customer service. You'll get unlimited consultation with the trust writer. You can attend the webinars that are done at least quarterly, right? I think you do those quarterly, where you can learn more about how to use natural law trusts and how to better protect your family. There's also additional options for other things that you can put with this. And there's some of those are on the Brilliance of Commerce website that you can find there. You're going to get access to a whole network of people that are also like you, wanting to protect themselves and their family. And many times you get to interact with some of those on these webinars, which is great. It's a good place to learn. There's a lot of information shared. Not required, but for those interested, bibliography is available for further study. In other words, if you want to understand more about the trust, I would get the ebook if you're still wondering about trying to, all this knowledge coming at you tonight and you want to further kind of digest that, get the ebook, Brilliance in Commerce, and that will give you something to study over time at your leisure where you can absorb that information. So you get so much value here, folks. I'm telling you, I've dealt with lawyers. The cheapest trust I could find through a lawyer was $5,000. Folks, this is half that price. It's a freaking bargain, and you get way more, way more. All of these are just parts, components to that. So, certainly I thought it was worth it. And it has been. It's been fantastic. What else we got? Consequences of procrastination. Some people look at that and say, yeah, you could do this later. If you're coming into wealth or you're coming into an increase where you're not sure how you want to deal with that, you may consider setting the trust up ahead of time, or you could do it afterwards. I mean, if you feel comfortable doing that. So it's all up to you, but no one's going to tell you, oh, you got to do this by a certain date or you're going to lose out. That's nonsense. But there could be things that come at you if you're having potential situational changes. So just be wise for yourself and for your family.
It's kind of like fire insurance. You don't wait until your house is burning down to buy fire insurance.
Yeah, that's perfect. All right. Easy way, be the trustee of your own trust, right? Take care of your own future and chart your course for yourself and your family, or you can go through all this other nonsense and pay the piper every year. Make sure you don't miss that payment or they're going to cut you off, as I've seen in some actual real situations. So I think we got through the gist of it. Folks, I want to get to the Q&A while we still have some time. And there's some really good questions that are probably in the chat. I haven't pulled it up yet. But do you want to open it up where they can ask online, or are we going to read them?
Oh yeah, we have people raising their hands. We got questions in chat. So Vernon,
Okay.
you've got your hand up. Would you like to speak to us?
Sorry, what?
Yes.
Vernon.
Can you hear me?
Yes, sir.
Yes, we hear you.
Can you? Okay, great. Perfect time because I had to run. I do have one call. I'm getting ready to start. Will, it sparked an interest in me because I remember in Germany they had a rush on the banks. Okay, people would run into the banks and what have you, and I know that's getting ready to happen. Even within the United States. Question with the international trust, I do know that laws do change. You know, I'm talking about in the United States. What's the chance of the laws changing internationally where we're not protected, if that's possible?
The only concern that I have in that regard is if some country was to revoke the right to private contract. That's really the basis of why we can do these. So that's really your only big concern. I think anything else can kind of be dealt with. But that would be the only thing that would be a concern of mine.
Okay, what's the likelihood of that?
I think it's very low. The moment they cut off the right to contract, all commerce
Very low.
stops. Yeah, I don't think any country would do it. It would literally be the death of their country to do it.
Yeah, it'd be almost impossible.
Okay.
Yeah.
Okay. All right. With that answer, I'm feeling rather comfortable. So I got one more question. With multiple end streams of income, do I need multiple international trust funds, or can I bunch them all into one?
They could be in one if you wanted it that way. It just depends on whether you need to, again, as I spoke about earlier, do you need to isolate risks or liability? because those might dictate your choices of whether you need more baskets to hold your assets or if one is enough.
Okay. Awesome. Gentlemen, I'd like to come back. I do have a ton of questions, but I'm
Oh,
pressed for
we're going to
time. I
probably have to
start on
limit it to
call.
just 2 per person. I'm sorry.
minutes
Just
Thank
we've
you
got
very much.
so many coming at us. There was one on the
Okay.
chat that I did see that I'll just address while you're getting the
right.
next person ready, Tonson.
Okay. Thank you
And that
for
is about,
Thank you. Thank you, gentlemen. God bless.
oh, you're welcome. Thanks for being with us. The question was about beneficiaries. Could beneficiaries change after the trust has been created? And I actually want Randall to answer that question, but it's a great question.
That's a yes. Beneficiaries will change. Some beneficiaries will pass on. Some beneficiaries will decline the benefit, and some beneficiaries will be cut out from the beneficiary because they are not capable of handling them themselves. So yes, that will change over time, all through time. You have to remember that once you set this up, this could go on for 200, 300, as long as you want, years, just like the Rockefellers, like anybody else. If you want a legacy for your family, now is the time to start.
Again, folks, you need to, that's really going to be a decision of your trustee. So if there's some adverse condition going on, the trustee, if he has the capability or the discretion, can make those adjustments or changes as long as he's not violating the intent of the trust or the contract.
Right, correct.
Okay, JH, you have your hand up. Would you like to speak to us?
Hi, thank you very much for hosting this evening. I'm definitely signing up. Yes, regarding the natural trust and opening up a bank account, my understanding is you have to have an EIN number to do that. You have to, they want some sort of government issued number to do that. Am I correct on that?
Yes.
Yes, you are.
Okay, so what about setting up this trust with you without an EIN number and instead setting up an LLC with an EIA number and having some sort of management agreement between the LLC and the trust where the LLC is basically the banker for that trust, so that trust stays completely private?
No,
Why not?
if you're going to set up an LLC, the owner needs to be held in a private manner. In other words, if you set up a government entity LLC, the owner will have to be recognized. So you have to be really cautious there. It doesn't mean you can't do it. We've done it numerous times. Sometimes it's easier to set up an LLC and let the trust and the client be the owners, and then it's fine, because then the government's fine. They have a storefront that they can tag, and then the back office is private.
Okay, so you're saying that there's no way to set up a natural law trust without an EIN, and that natural law trust has got to have an EIN number associated with it?
You
It
can, but it's
depends.
depending upon the bank. It's the bank that is resistant to allowing you to come in with with a contract between you and your neighbors. It's the government owns the bankers, as Will point out repeatedly, and the bankers dictate to you what they will do if you want to be their customer. Whereas it should be, hey, Mr. Banker, would you like me to be your customer? So it's reversed, and unfortunately, that's the bottom line. Is basically you can't get an account in the U.S. without some kind of EIN number.
Right, but
The-
that's what it's basically trying to say, that I could have an LLC that has an EIN number associated with it, and then open up a bank account, but they don't need to know that the trust owns that LLC, because that's a private contractual agreement between the trust and the LLC.
That's correct.
When you use an LLC, however, they require that information to actually let you form it.
Right.
And
No, they
they're gonna
don't.
require, they're gonna require the, well, it could vary by state because each state's a little different.
Yeah, I mean,
Um,
if you set up a LLC in a couple of states, I think Las Vegas is one, but I set one up in South Dakota, and my name is not on that at all. I have a registered agent, and I'm just a managing member of that LLC. Nobody knows that I'm an owner of that LLC.
That's correct. That's what they're for.
that's, you can be as creative as you want to be. If you're getting an EIN, there is a way to do it where you stay aloof from the system. In other words, it's a process of being an exception, not, what's the other word, Tonson?
Exempt.
Exempt. Yeah, you don't want to be exempt. You want to be an exception.
It's far
So
Right.
superior.
But you can get that guidance. Randall will help you through that process if you need it.
Okay, thank you. I really appreciate that because I mean, anyway, if this I mean, I'm hoping I've seen a lot of documents on the Office of the Comptroller of the Currencies website as well as the Treasury's website. If you go into the back end and you do some major searches, you will see that the QFS is running parallel to the SWIFT system right now. So I'm hoping and praying that this SWIFT system goes quickly and we go to the QFS, because then I guess my understanding is we go to common law and all these attorneys have to be re-educated on common law. And then we don't really have to worry so much. I mean, the IRS is going to go away with Nasera, Jacera, or Nesra, Jessera, however you want to pronounce that.
Yeah.
But I guess in the interim, I don't want to wait anymore. I just want to come to you guys and get this stuff done. It's like, I don't want to wait for my house is on fire to get insurance. I just want to get this out of the way and done and be done with it.
Well,
And
JH,
there's a way to do that. I've done it as
Yeah.
well. My trust does have an EIN, but it's only for banking purposes. That's the only reason for it.
Okay,
So
well, then
it's possible to do it.
I'm going to talk to you guys about that because I've been told by other common law trust attorneys that wanted my business that I didn't give the business to, that once you have an EIN number with your common law trust or your natural law trust, that you're no longer in the private anymore, and you've just negated the common law trust or natural law trust and become a statutory trust.
No, that's not correct. You're getting advice from the wrong people. That's completely wrong. So I
Thank you.
just wanted to say, JH, you have nothing to worry about. We've been doing this for decades. I mean,
Thank you. No, I've honestly, I've done a lot of
Yeah.
due diligence,
we've
and I'm going.
never had a problem. We still operate in the private.
Yeah.
The only thing they know when you get the EIN is the name of the trust, who the responsible party is, and the fact that it's irrevocable. That's all they know. So the
Yeah.
rest of it, all of its activities, all of its officers, beneficiaries, all of that still remains private. So
All right, thank you. I'm going with you guys.
Thank-
I've already done my due diligence.
Thank-
So I'm going to be calling you guys tomorrow and submitting my money because I just want to, I'm done. I'm going to, as my mother used to tell me all the time, shit or get off the pot.
Well, thanks for being
very
with
much.
us tonight. We
Thank you.
appreciate that.
Thank you, Will. God
Um,
bless you guys. I'll let somebody else
you're-
ask a question. Thank you.
Thank you.
You're welcome. I want to touch on one of the questions that's in the chat while you're looking for the next one there, Tonson.
Okay.
Question is this: would you have a humanitarian project as a beneficiary of a trust, or should you set up a separate new trust for the project? Great question. What do you want to do with this project? If it's going to function as a business, make it its own trust. There's no reason you can't do that. And even if you don't have the funds to put into it now, you can start it and set it up. The money can always be placed in later. So no problem with that.
All right.
It could be a beneficiary as well, though. I'm not saying that it couldn't be both of those, because if you've got some funds coming from some income stream that you want it to go to a specific project, you could, it could be a beneficiary. In other words, a trust can also be a beneficiary. So just make that clarity there.
Yes.
That's good, Will. Yeah, you're right on. The trust can be beneficiary, and the trust itself can have humanitarian projects that the trust would supply funds to. So it's just a pass-through, and it's a perfect vehicle for going from somebody's hands to trust into the beneficiary's hands. And again, it's back to your discretionary ability. If the trustee has that, then this trust will run flawlessly.
Yeah, it'll be great.
Okay,
Okay, Johnson, who's next?
Nancy, you're up next if you want to say hi to us. Nancy STL.
Maybe she's muted. I can't hear her.
Maybe she,
Okay, there we go. I was having difficulty unmuting. Thank you for taking my question. All right. I have some similarities to the person right before me, but here's my situation. So I very recently set up a common law trust just to have something in place for hopefully upcoming appointments, if you know what I mean. And so I set up this common law trust now, but it has an EIN number. And so, well, it was my understanding that that was kind of the way that I had to do it. I'm hoping that I can undo that. I mean, if I were to set up an NLT with you, then would that make the other one go away, so to speak? What's
It could
the
be
best
done,
way?
yeah, you can put it on the closet shelf and just let it sit there.
Okay, because I have received something from the IRS saying that I must file a Form 1041 by April 15th of 2025.
Oh yeah, they love that. They love to send you that notice.
So I can
Okay.
just
I have
pretend that,
I have a drawer full. My bottom drawer in my desk is full of 1099s. That's all I'm gonna say.
I thought they were in your round file.
Yeah.
Yes.
That bottom drawer is round, I think. Every time I look at it, it's empty. It's like an
Yep.
empty circle pit.
okay, so in other words, if I go through you, what you all set up for me will supersede entirely this other common law trust that I set up with an EIN number. Is that correct?
I can't say that until I look at the document. The document may be fine, and it's that you're not getting the support you need. So we can supply the support, or we can supply you a new document, depends. So please,
Yeah,
we can, connect up and ask for a consultation, and we'll go from there.
all right, very good. Thank you.
Thank you,
welcome.
Nancy. Okay, Blair, you want to say hi to us?
Yes, sorry about that. I had my mouth full of popcorn. Trust, holding company, corporations, are they not all basically all legal fictions, just documented differently? And I imagine all this would be similar in Canada as in the US in general intent of setup. Also, will we really need all this going into Nacera and Jacera?
I think the last part of the question, I think the requirements are going to be very minimal because there's not going to be any income tax. Okay, we are moving into that. I don't know when that's going to be effective, but we are going to have that. So that means you're not going to have to document everything the way that you would. In regards to the other part of the question, will it all just simply go away? Even with Nacera or Jacera, it doesn't affect in any way the function of these trusts. These can function under any environment as long as the right to contract exists. So even if you have one of these and the rules change, it doesn't affect you at all. You just continue on.
So it doesn't hurt to set one up now or later. It's just basically we all should set one up.
Better now. It's
Sooner
for
the better.
setting the foundation. It's like concrete wants to settle. The more you leave concrete in the weather, the harder it gets. So look at it that way.
Okay, fair enough.
Great questions. Thank you.
No problem.
Thank you,
Thank you.
Blair. Tamara, you have a question?
Yes, I do. I wanted to get a simplified explanation to the 98 EIN number versus the 99 EIN number. Will, would you be able to help clarify the difference?
There is a specific way that you must fill out the form to request that. And you want to have help walking through that, because if you do it properly, you're not going to have any issues. The problem is many times people fill them out incorrectly, and then the IRS gets the idea that you are in the system even though you're not, right? So it's
Mhm.
important that be done properly.
Specific instructions on that come with your trust. Which boxes to fill out, what words to use, what words not to use. It must be followed exactly. It takes 15 minutes. It's free, but you have to follow those instructions.
Okay, well, I referred one of my clients. He's on the call right now. This is his first call, and he has two EIN 99 numbers. And he would like to get the trust. Can anybody work with him? He's been trying to learn more about it.
You can't use an existing number. You have to get a whole new number according to the specific instructions that come with this trust.
Okay, all right, thank
Right.
you.
Yep.
Mhm.
We'll
We
take three more, Tonson, and then I'm going to have to go. So we'll do three more questions.
We have at least 50 questions in the chat. I don't think.
We may have to do a follow-up with questions.
All right. Someone's saying, can one person create multiple trusts for family members with different grantors, EINs, who will sign off with you as, I guess, POA, power of attorney? They sign an NDA and they'd sign a memorandum of understanding. You will control assets to flow in or out. Assets are placed in each trust. However, the POA has control of assets going in or out.
Wow. What? Okay.
Yeah, we can do that.
You can
Just
you
send us
can have
money.
a separate trust for every beneficiary, of course,
Right.
with its own requirements.
Yeah, suffice it to say, each customer, each client customizes his trust. Once you are a client, you have customization and one-on-one consultation with Randall and his team. So any customization, unique tailoring, specific requests are accommodated. Okay. Is there a register that natural law trusts to avoid anyone having the same name for a trust?
I haven't seen it yet.
It's private, so there's no registry. It's just whatever the grantor and the trustee want to agree to.
Mm-hmm.
And I have had the IRS say that the name has been taken, but because it's in a different state, they have given a IRS number or EIN number for that trust because it's in that particular state. But there's usually not an overflow. On the corporate entity side, if you have the same name, you can't use it because that's a statutory process. Whereas with the trust, it's all private, so it's a private contract. So the names could be the same.
Margie's saying, is there a situation where it would be advisable for a trust to do business as? And I'll just say, Margie, that's what I'm doing with Brilliance and Commerce. Brilliance and Commerce is a DBA. Yeah, the trust name is held in the background. Will, you have a comment?
Yeah, no, you can absolutely do that. It's possible to do that. The great news, I think, for all of us coming is that with the upcoming rule changes, I think you're going to find different leniency coming from financial institutions. In other words, they may be so desperate for your business, they don't care if you have an EIN or not. Okay. In my case, it was only for a bank account. In fact, that was stated right on the application form. So some people are like, oh, if you get an EIN, it's all over. You're now part of the system. That's not necessarily true,
No.
because we've been doing this for a long time. And, but I understand everybody's apprehension of trying to be drug into some statutory nonsense. So just keep that in mind. We do hope and certainly pray for a change in the conditions that would eliminate that need. Because if we don't need that, we're all happy to go without it. Absolutely. Okay. Anything else? Tonson, let's do one more and then we'll wrap it up. Okay.
Okay, Blair's saying, will this presentation be posted on the BIC Rumble page? Yes, Rumble and YouTube. We'll put it on both. And Will, you're going to put it on your channel as well?
Yep.
And
Yep.
Rumble?
It'll be up on our Rumble channel as well. Yep.
Okay. All right. Let's
Want to
see.
thank everybody for coming tonight. I know we were limited on how many could get on. With Zoom has some limitations of how many can attend. I'm not sure where we were at with our total numbers, Tonson. I think we're pretty high tonight, actually. But the replay, anybody can listen to that. So hopefully that's helpful for you. We'll consider doing another round of Q&A later, because there's always questions regarding these topics. I'm not sure when that'll be, but we'll let you know.
Natalie's saying, does anyone here have a crypto exchange account set up in the name of a natural law trust? And I'll just say yes. I have an account at Coinbase, which is America's largest crypto exchange. Okay, everyone, next week.
We have a couple of clients. We have a couple of clients like that. And I'd be happy to answer some of these questions next week when I'm going to talk about trust. And Will is welcome to come and we'll co-host it.
Yes.
Oh, what day are you doing that?
There you
Wednesday,
go. Screen.
Thursday?
March 20th, Wednesday.
March
To
20th.
do,
Okay.
21st. Isn't 21st the Ides of March?
Yeah, but your webinar's on the 20th.
Oh, okay. The 20th it is.
Okay, next Wednesday. I might be just a little late, but I think I can get on.
Okay.
Tag in with us.
Perfect. Sounds great.
All right, everyone. Thank you for joining us. It was fantastic. We could have gone on for hours and hours more, but we'll continue some other time. Thank you for joining
Thanks,
us.
everyone. Have a great night.
Thank you, Will. Thank you, Randall.